topic in Chapter 4, Section 51 to Section 59. And we are the Group 1!
그걸 본 네가 본 네가 따라라라라리 널 보고 있으면 말게 baby 너를 위한 멜로디 yeah. 네가 뮤지니까 잘 들어봐 play it 너에게 닿길 바래 all for you 따라라라라리 널 보고 있으면 말게 baby 너를 위한 멜로디 yeah. 네가 뮤지니까 잘 들어봐 play it 그걸 본 네가
We hope that you can learn and understand from our topic for today. So what are you waiting for? Let's go!
Good morning, Philippines. Good morning, Manolo Fortich, and good morning, NBSC. We are the Group 1 who will present the Chapter 4, Section 51 to Section 59, the rights of the holder. When we talk about holders, who are we referring for? Actually, we are referring to what we call as a holder in general, a holder simple, a holder in due course, a holder not in due course. And that also includes a holder for value, a holder in general, or holder simply is any person who is in the possession of the instrument. Holder for values, obviously, any person is given valuable consideration. A holder not in due course is one who is able to meet the requirements in the Section 52, which can be discussed by my group mate. But the question is, who is a holder in due course? So, let's talk about and discuss this topic from Section 51 to Section 59, which is Mary Ann Barsobia will begin to discuss. Mary Ann?
Thank you, Ms. Arlene. By the way, I am Mary Ann Barsobia, 19 years old, and I am currently in BSBA Financial Management. Section 51, right of a holder to sue payment. The holder of a negotiable instrument may sue thereon in his own name and payment to him in due course discharges the instrument. The holder is any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. Instrument is a signed document that promises a sum of payment to a specific person or the assignee. In short, instrument is a transferable signed document that promises to pay the bearer sum of money at a future date or on demand. The holder has been provided with certain rights to sue the instrument in his own name, even if he is a holder only for collection or a pledge of instrument. There are three ascending order of rights and holders. Number one is holder simply, any person who is in possession of the instrument. Holders for value, any person gives vulnerable consideration in that instrument. Third one is holders in the due course, the one who has obtained the instrument for consideration and is good faith and before maturity. The law gives you the right to litigate against any person, company, or entity who has wronged you in some way. By filing a lawsuit, you can seek justice for the losses or hurt that you might have incurred because of the action of other entities. Example, you may have entered into a contract with an entity for, say, before some service or buying a car or any other item. You can litigate for justice if you think that the other entity has not complied with the terms and conditions outlined in the contract.
Thank you, Ms. Arlene. By the way, I am Juna Marie de Gonzaga, 18 years old, from BSBA Marketing Management. My topic is in Section 52, what constitutes a holder in due course? A holder in due course is a holder that has taken the instrument under the following conditions. Four following conditions. A. That it is complete and regular upon its face. Complete means it should be mechanically complete instrument, nashai, signature, amount, date, and there are no entries left blank. And regular is if there are erasures and insertions of the instrument, you have to countersign it to prove that you are the one who wrote it. Next is B, that he became the holder of it before it was overdue, and without notice that it had been previously dishonored if such was the fact. Kailangan makonsider ka as a holder in due course if you receive the instrument before its maturity. And matawag ka as a holder in due course kung wala ka kabalong it has been previously dishonored by non-payment and an acceptance. Next is C, that he took it in good faith and for value. Good faith here is the state of mind, and the value is you have to prove that you prove that you value the instrument you received. Now, letter D, that at the time it was negotiated to him, he had no notice of any infirmity in the instrument or defect in the title of the person negotiating it. No notice kay mo na siya imong personal knowledge o actual knowledge. So, matawag ka sa holder in due course kung wala kay alam nga naani siya ang instrument na infirmity. Infirmity means forgery and insertions. And you have no notice that it has defect in the title of the person. Defect in the title is na-acquire na siya nga instrument using vices of consent. Meaning, na-acquire na siya by fraud, violence, and intimidation. Okay then, next. Conditions to qualify one holder in due course. Number 1 is presence of all conditions. As what I've mentioned earlier, katong upat nga conditions ma-acquire nimo para matawag ka sa holder in due course. If ever nga na missing adto nga one part, consider na din ka as a holder not in due course. Number 2, status as mere assignee. The holder of a non-negotiable instrument cannot acquire the title of holder in due course because he is just a mere assignee subject to defenses. And he cannot acquire rights under the law than those who possessed by assignor. Number 3, rights of holder in due course not in due course. A holder not in due course has all the rights. Ang nakaapan lang is if ever nga naay nakita nga and maka-acquire pud siya o great rights under negotiable instruments possessed by the payee or endorsee. Next, payee as a holder in due course. There are marked two conflict opinions on this point. Number 1 is contrary view. Ang sa contrary view, kailangan daw ang holder ma-acquire niya ang instrument through negotiation, and it should be issued. The instrument should be issued and not negotiated with a payee. O ang sa ikaduha pud nga opinion, which is the affirmative view, kay gina-consider niya ang payee as a holder in due course who possessed the instrument. Okay, next, Drowie as holder in due course. So si Drowie is not considered as a holder in due course kay ma-consider lang siya as a holder if iyahan ang napasa ang instrument. Kay si Drowie mo man siya ang nag-accept sa instrument. Next is instrument complete and regular upon its face. Number 1, wanting in any material particular. Mao na ako na-mention earlier nga kailangan ang instrument kompleto siya, naa siya signature, amount, date, and there are no entries left blank. Ang number 2 is alteration apparent on face of instrument. So, mao na siya ang gipasabot adtong first condition nga regular upon its face na if there are erasures and insertions sa instrument, you have to countersign it para ma-prove nga you are the one who wrote it. Next, holder before instrument is overdue. 1. Date of maturity. Date of maturity is nana siya types A, B, and C. Ang A is katong fixed date nga nakabutang sa instrument. Ang B is if it is on demand payment is ma-determine ang ang maturity and date of maturity sa that time nga gi-present nimo ang katong nga instrument. Og so C, if the instrument is if the instrument is payable on the occurrence of a specified event which is certain to happen, then the date of maturity is fixed by the happening of the event. Next, holder without notice of dishonor. Mo ni akong giingon ganina ha. Notice of dishonor if it's previously done by unacceptance and non-payment. Holder in good faith. Meaning of good faith. It means honesty in fact and the transaction of concern. Mo ni siyang gingon ganina nga naani siya sa state of mind sa holder. Meaning of bad faith. It means that he must have knowledge of facts which render it dishonest for him to take a particular piece of negotiable paper. Next is proof of bad faith. To show knowledge of such facts that the taking would amount to bad faith. It is not necessary to show knowledge of the exact truth. Holder for value. Holder for value kay mo na siya ang dapat you have proven that you value the instrument you receive. Next, holder without notice of infirmity and instrument or defect of title. Holder without notice, ang infirmity, as what I have said earlier nga, it is forgery and not forgery and insertion sa instrument.
Thank you, Juna Marie. By the way, I'm Diana Rosiaco, 19 years old, taking the BSBA major in financial management. So, section 53. When the persons not deemed holder in due course, where an instrument payable on demand is negotiated an unreasonable length of time after its issue, the holder is not deemed a holder in due course. So, holder in due course is instrument payable on demand. One of the requisite of due course holding is that the holder of the instrument becomes such before it is overdue in section 52. It obviously applies to an instrument payable at fixed or determinable future time. With respect to an instrument payable on demand, section 53 governs in determining whether the purchase is one of the overdue instrument. As what that constitute a reasonable time, the law provides the regard is to be had the nature of the instrument, the usage of trade business with respect to such instrument and fact of the particular case. When we say constitutes unreasonable length of time, it means jurisprudence doesn't state the exact period. Nonetheless, there are particularly no authorities hold that a reasonable time for negotiating a demand could not be extended beyond the year.
Thank you, Miss Diana. I'm John Benedict D. Gonzaga, 19 years old, BSBA Marketing. My report for today is Section 54. Notice from full amount paid, where the transferee received notice of any infirmity in the instrument or defect in the title of person negotiating the same before he has paid the full payment agreed to be paid. Therefore, he will be deemed a holder in due course only to the extent of amount therefore paid by him. Kung makareceive ka og naay daot or mali ang document, tapos sa paano mo nabayaran ang full payment, ma-entitled ka og holder of due course. Holder of due course kinakay ikaw mag-vote kung ano sa ka magbayad, tapos pero nadepende po niya sa inyong unangan na bayaran. Effects of notice before full payment. No amount has yet been paid, where an instrument has been taken but the purchaser has not been paid anything. And he receives notice of infirmity in the instrument or defect in the title of the holder. He is relieved from the obligation to make payment. If he does so, it is quite clear that he is not entitled to the same protection as a holder in due course. Ang meaning document na nakuha na pero wala pa siya nabayari bisan piso or bisag unsa. Tapos after makabalo din ka na ay daot or defect ang instrument may mo na dawatan na mawadan kag obligasyon para bayaran ang instrument. Hindi ka plano magbayad, dili ka entitled sa holder of due course. 2. An amount has been paid where the instrument has been transferred to him in consideration of his promise to make future payments to his transferor. He is under no legal obligation to pay the balance of the amount he has agreed to pay in discovering the infirmity or defect. If he does, he is considered a holder in due course only to the extent of the amount, therefore paid to him. Ang document or ang instrument kaya transfer na kaya nabayaran na siya o kaya na-promise po siya nga magbayad siya sa future. So yung kulang nabayaran mo. Kung na-discoveryan na naay mali or daot sa document or instrument nga nadawat, wala siya obligasyon nga bayaran ang balanse sa nasabutang kandidat. Kung makadiscover man sa kani og daot, makonsider na din siya og holder of due course.
Thank you, Benedict, for your comprehensive topic. I'm Melissa Silogonyo, 19 years old from BSBA Financial Management. My topic is Section 55 and title is Defective. The title of a person who negotiates an instrument is defective within the meaning of this act. When he obtains an instrument, he is signature. Therefore, by fraud, duress, prefers unfair, or other unlawful means or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. There are three makers entitled defective. First is liability of maker unconditional. The maker is undoubtedly a party primarily liable as he is the one to whom the holder will look first for payment and the one who is expected to pay. Second is admissions of maker. The maker admits the existence of the fee and his capacity at the time of signing the note to endorse. Third is presumption arising from signature. A person placing his name on the face of a note is prima facie. A maker unliable as such, he is presumed to have adopted with care and have signed the instrument in question with full knowledge of its contents. There are two ways when the title of person is defective. First is when he is acquisition, and second is when he is in negotiation. For example, supposedly, B finance a car to an auto lender. B is unable to sell the car to another person, so there will be a lien to a car. Lien is a right to keep possession of property belonging to another person until a debt owed by that person is discharged or fully paid. So in this situation, the auto lender is still the legally ownership right on the car until B is fully paid the loan or the debt before owning the instrument. So in summary, the defective title is unable to be legally transferred the instrument to another person until liens or other debts and issues are settled. Back to you, Miss Arlene.
Thank you, Monique, for that very comprehensive report. By the way, I am Jackie Tinga from Diploma for Teach Bukidnon. I am 25 years old. For now, I am taking BSBA a major in Operation Management. My topic for today is about Section 56. What constitutes notice of defects? To constitute notice of an infirmity in the instrument or defect in the title of a person negotiating the same, the person to whom it is negotiated must have had actual knowledge of the infirmity or defect, such as facts that his action in taking the instrument amounted to bad faith. To constitute a notice of defect or infirmity, the holder must have actual knowledge either of the defect or infirmity or of the facts that his action in taking The instrument amounts to bad faith. Thinking amounting to bad faith. Bad faith consists in guilty knowledge or willful ignorance showing a vicious or evil mind, while mere suspicion is not enough where there is knowledge of suspicious circumstances. Coupled in means of verifying them, taking the instrument may amount to bad faith. For example, is that holder refused to say how and why the stolen check was passed to him by the culprit. Facts is that pay purchased from D, which is the bank, a cashier's check for 800,000 pesos. The check was stolen from this manager to whom he entrusted the check for safekeeping. The facts pointed to A as the culprit. P immediately accomplishes stop payment order. B, the holder of the check, when asked how he came to possess the check, saying it was paid to him by A in a certain transaction, but refused to elucidate further. An information for theft was instituted against A. Issue: is B a holder in due course? Held: no. B refused to say how and why the check was passed to him by A, who stole the check. He had therefore notice of the defect of his title over the check from the start. That would be all. Thank you.
Thank you, Miss Jackie. So, by the way, I'm Laarni Pearl Birrella, 19 years old. I'm taking up BSBA Marketing Management. So let's talk about the rights of a holder in due course. In general, meaning rights which will apply to all of the holders now within the due course, not in due course, and holder of value first, of course, under Section 51 is that any holder can sue on negotiable instrument in his own name. Okay, he may enforce the negotiable instrument in his own name. And second, he is entitled to receive payment on the instrument, and if the payment is done in due course, meaning the payment was made up of after the majority to the holder in good faith and without notice that his title has defected, then the instrument will be discharged. And that's all. Thank you.
Thank you, Miss Arlene. Hi, everyone. I'm Danimi Bayagna. I am going to report about Chapter 4 Rights of a Holder, Section 58, in subject to original defenses. In the hands of any holder other than a holder in due course, a negotiable instrument is subject to the same defenses as if it were non-negotiable, but a holder who derives his title through a holder in due course and who is not himself a party to any fraud or illegally affecting the instrument has all the rights of such former holder in respect of all parties prior to the latter. So what is defenses in general? Defenses are grounds or reason pleaded or offered by the defendant in a case showing why the plaintiff as a matter or law or fact should not be given the relief he seeks. O ang mga depensa mao ang mga sukuranan o mga rason nga gihangyo o gitanyag sa sinumbong usa ka kaso nga nagpakita ngano nga ang reklamante isip usa ka butang sa balaod o kamatuoran dili kinahanglan nga hatagan sa kahuyapan nga iyang gipangita. There are two kinds of defenses which may be interposed to an action upon a negotiable instrument: real, absolute, universal defenses, and personal, limited, or equitable defenses. Some defenses are either real or personal, depending on the factual situation, out of which arise the particular defense. First kind of defenses. Real defenses are those that are available against all parties, both immediate and remote, including holders in due course, or holders through the latter. In other words, there are cases when a holder in due course is not legally entitled to payment from the primary party. They are called real because they attach to the rest. RES, that is, the instrument itself, regardless of the merits or demerits of the holder or the conduct or agreement of the parties to it. They challenge the validity of the instrument itself.
It cannot be enforced by the holder because there is no contract to enforce. O ang tinuod nga mga depensa mao ang magamit batok sa tanan nga partido. Pareho, diha og hilit. Lakip ang mga naghupot sa tukma nga panahon o mga naghupot pinaagi sa ulahi. Sa laing pagkasulti, adunay mga kaso kung ang usa ka naghupot sa tagdang panahon dili legal nga adunay katungod sa pagbayad gikan sa panguna nga partido. Gitawag sila nga tinuod tungod kay ang nag-attach sila sa RES or RES nga mao ang instrumento mismo bisan unsa pa ang mga merito o demerits sa naghupot o ang pamatasan o kasabutan sa mga partido niini. Gihagit nila ang pagkabalido sa instrumento mismo. Dili kini mapatuman sa naghupot kay walay kontrata nga ipatuman. There are some examples of real defenses. A. Incapacity as far as the incapacitated person is concerned o incapacity kutob sa incapacitated nga tawo. Illegality of contract when declared by law except where the maker or drawer is himself a party to the illegality. Thus, a note for a gambling debt, an illegal consideration, is a mere personal defense want of delivery of incomplete instrument. O illegal sa kontrata kung gideklara sa balaod gawas kung ang magbubuhat o drawer mismo sa kapartido sa illegalidad o illegal. Busa ang usa ka nota alang sa utang sa sugal, usa ka illegal nga konsiderasyon. Kay usa lamang ka personal nga depensa gusto sa paghatod sa dili kumpleto nga instrumento. So number 2, personal defenses are those which grow out of the agreement or conduct of a particular person in regard to the instrument which renders inequitable for him, thou holding the legal title to enforce it against a party, so to be made liable but which are not liable against a holder in due course, or holders with all the rights of a holder in due course. They include every defense assertable in action under ordinary contract law. They are called personal defenses because they are available only against that person or subsequent holder who stand in privity with him. In other words, they can be used only between original parties or immediate parties or against one who is not a holder in due course. There are some examples of personal defenses. A. Filling of wrong date o pag-ili sa pitsa kung sayop. B. Filling up of blanks not in accordance with the authority given and within reasonable time. Ang pagpuno sa mga blanko dili subay sa gihatag nga otoridad ug sulod sa makaturunganong panahon. Letter C. Want of delivery of complete instrument o gusto sa paghatod sa kumpleto nga instrumento. D. Absence or failure of consideration, wala o kapakyasan sa konsiderasyon. E. Simple fraud or fraud in inducement, o yano nga pagpangilad o pagpanikas sa pagdani. Immediate, remote, and prior parties explained. First, immediate parties. Assume that M makes and delivers his promissory note to P, the payee, and that P endorses to A, and A to B. M and P are said to be immediate parties because they are in direct contractual relation to each other. Where, however, M makes and delivers to X, an intermediary, is M's promissory note, payable to the order of P, and X delivers the note to P, payee. For value, M and P are not immediate parties. Immediacy signifies privity, not mere proximity. Number 2, remote parties. A remote party is one who takes title to an instrument by negotiation from either the original payee or any subsequent holder. In the preceding illustration, M and B are remote parties. That is, parties who are not in direct contractual relations to each other. Other pairs of remote parties are M and A, P and B. 3. Prior parties. In the example given in number 1 above, M, P, and A are prior parties with respect to B. A holder in due course is free from personal defenses available to prior parties among themselves. As between the immediate parties, no distinction need be made between real and personal defenses. So as between M and P, or P and A, or E and B above, we might say that all defenses are real. But when the instrument has passed to a remote party like in A in relation to M, The latter, a prior party, can only set up real defenses. However, if A is not the holder in due course, the instrument is subject to all defenses. In such a case, E is a mere assignee and the general rules on a contract would apply. Defenses available against a holder not a holder in due course. A mere assignee or one who is not a holder in due course takes the instrument subject to all valid claims of any party, which would be available in an action on an ordinary contract. Ang usa lamang ka assignee usa nga dili usa ka naghupot sa tukma nga panahon ang dapat mukuha sa instrumento ubos sa tanang balido nga pag-angkon sa bisan unsang partido nga mahimong magamit sa usa ka aksyon sa usa ka ordinaryo nga kontrata. Defenses subject to estoppel. Through estoppel, an admission or representation is rendered conclusive upon the person making it, and it cannot be denied or disproved as against the person relying thereof. Pinaagi sa estoppel, usa ka admission o representasyon ang gihatag konklusibo sa tawo nga naghimo niini ug kini dili ikalimod o ipaghimakak batok sa tawo nga nagsalig niini. Real and personal defenses are subject to estoppel, since the rules and principles governing estoppel generally are applied to commercial instrument. In fact, practically all the defenses such as forgery or illegality may be precluded by estoppel. Ang tinuod og personal nga mga depensa gipailalom sa estoppel tungod kay ang mga lagda og mga prinsipyo nga nagdumala sa estoppel kasagara gigamit sa commercial mga instrumento. Sa tinuod, halos tanan nga mga depensa sama sa falsifikasyon o ilegalidad mahimong mapungan pinaagi sa estoppel. Fraud in factum and fraud in inducement distinguish. There are two kinds of fraud relating to negotiable instrument, namely: Number 1, fraud in the execution or fraud in factum. It exists in those cases in which a person without negligence has signed an instrument which was in fact a negotiable instrument, but was deceived as to the character of the instrument and without knowledge of it, as where a note was signed by one under the belief that he was signing as a witness to a deed, or where the signature was procured by fraudulent use of carbon paper. Ug kini anaa sa maong kaso, diin ang usa ka tawo sa walay pagpasagad mipirma sa usa ka instrumento nga sa pagkatinuod usa ka negosyable nga instrumento. Apan nalimbungan may tungod sa kinaiya sa instrumento ug walay kahibalo niini. Sama sa diin ang usa ka nota gipirmahan sa usa ubos sa pagtuo nga siya mao ang pagpirma isip saksi sa usa ka kasulatan o diin ang pirma nakuha pinaagi sa malimbungong paggamit sa carbon paper. Number 2, fraud in the inducement or simple fraud. It is that which relates to the quality, quantity, value, or character of the consideration of the instrument. In this case, the signer is led by deception to execute what he knows is a negotiable instrument, and therefore necessarily signed with knowledge that the instrument would probably pass into the hands of an innocent purchaser. Her. The deceit is not in the character of the instrument, but in its amount or its terms. It implies that the signer knew what he was signing but that he was induced by fraud to sign. Kumao ka na ang nalangkit sa kalidad, gidaghanon, bili o kinaiya sa konsiderasyon sa instrumento. Sa kini nga kaso ang nagpirma gipanguluhan sa pagpanglimbong aron ipatuman ang naibalaan niya nga usa ka negosyable nga instrumento. Ubos sa kinahanglan nga pirmahan uban ang kahibalo nga ang instrumento lagmit mapasa sa mga kamot sa usa ka inosenteng pumapalit. Dinhi ang limbong wala sa kinaiya sa instrumento, apan sa kantidad niini o sa mga termino niini. Nagpasabot kini nga ang nagpirma nahiblo sa iyang gipirmahan, apan naaghat siya sa pagpanglimbong sa pagpirma.
Thank you, Danny May. By the way, I am Arlene B. Kalambuhay, 31 years of age, taking up BSBA Marketing Management. And this will be the continuation of Section 58, Rights of the Holder. He can sue on the instrument of his own name subject, of course, to a personal defenses, both personal and real defenses, which may be used against him to prevent him getting paid, and he may receive payment if it's in due course, then it discharges the instrument again, subject to the personal and real defenses. So in other words, the third right is that he holds the instrument subjected the same defenses as if it were non-negotiable, meaning both personal and real defenses may be used against him. Right of forfeiture from a holder in due course. It is whether a holder takes a negotiable instrument free of equities and defenses that might obtain between the original parties depends upon the further fact of his status as a holder in due course or as a taker through such holder. So there are two types. This is the right of a mere transferee and the right of transferee from a holder in due course. So the right of a mere transferee is a person who is a holder in which due course is only right is the only transferee of a non-negotiable instrument. So in only the transferees only is a person can do in a right of a mere transferee. So the second one is the right of transferee from a holder in due course. So it provides exceptions. A holder who derives his title from a holder in a due course has all the rights of the latter, even though he himself is a mere transferee. That's all in section 58. Thank you.
Thank you, Ms. Arlene. My name is P.K. Chavez. I am 19 years old, currently taking BSBA Marketing Management. I'll be talking about Section 59, who is the holder in due course. Every holder is named prima facie to be a holder in due course, but when it is shown that the title of any person who has negotiated the instrument was defected, the burden is on the holder to prove that he or some person under whom he claims acquired the title as holder in due course. But the last mentioned rules does not apply in favor of a party who became bond on the instrument prior to the acquisition of such defective title. The presumption here is where the transferee received notice of any infirmity and the instrument or defect, the title of the person negotiating same before he has paid the full payment agreement to the paid. Therefore, he will be deemed a holder in due course only to the extent of the amount therefore paid by him. Therefore, paid of being a holder. Once the person whose hands an instrument has passed shows that he is a holder, the presumption occurs in his favor. He does not have to prove that he have complied the requirement as a holder in due course. Example, and next, a promissory note later is issued to P or order. P to A, A to B, B to C, C to D, D to E. All of them is a title holder in due course. However, if X claims that E is a holder not in due course, E is not required to prove that she is a holder in due course because X claim is just allegedly accusation. Another part of it is the burden of proof on holder where endorser's title is defective. If X is proven that B is a holder not in due course, C, D, and A are no longer acquired the presumption of holder in due course. However, if the negotiation is acquired before the presentation of proof that B is not a holder in due course, C, D, and E will enjoy the presumption of holder in due course. Thank you, that's all.
널 보고 있으면 I give baby 너를 위한 멜로디 yeah 네가 뮤지니까 잘 들어봐 play it 너에게 닿길 바래 all for you 널 보고 있으면 I give baby 너를 위한 멜로디 yeah 네가 뮤지니까 잘 들어봐 play it 그걸 본 네가 널 보고 있으면 I give baby 너를 위한 멜로디 yeah 네가 뮤지니까 잘 들어봐 play it 그걸 본 네가